Good morning. Today we are going to discuss about Salmond's views relating to law. Okay, what he is telling, law is justice, speaking to men by voice of the state. Salmond is giving very much importance to the judiciary and to the purpose of the law, that is justice. He says that the main purpose of law is what? To provide justice. Okay, now what his definition is? He defines as, law may be defined as body of principles recognized and applied by the state in the administration of justice. Okay, law may be defined as body of principles which are recognized and applied by the state in the administration of justice. Means there are only three elements of Salmond's definition. What is law? Law is a body of principles. It is being recognized and applied by the state. Means only when the state recognizes, only when the state applies, those can be called as a law. And why it is being brought? It is being brought for administration of justice. Means for the sake of justice, law is made. The main purpose of law is what? Justice. So he says that law consists of rules recognized and acted upon by the courts of justice. He has given much importance to the judiciary. He says courts may misconstrue a statute. Means he is saying that they can misinterpret a statute or reject a custom. It is only the ruling of the court that is binding force as law. Means it is only the ruling of the court that has binding force as a law, and it is a law. Means it may be misinterpreted also, it may be misconstrued also. If the highest court of the state willfully misconstrues an act of the legislature, the interpretation so placed will become a law. Means he says that if the judge misinterprets and gives a wrong judgment, it is a judgment, it is a law, though it is been misconstrued, though it is been misinterpreted. Such an importance Salmond is giving to the judiciary and to the court. Salmond's definition is telling to us the ethical purpose of law. Means why law is there? Law is an instrument of justice. Law is there for justice. Okay, we'll see again what is law. Law is body of principles. They are recognized and applied by the state for administration of justice. He speaks about the purpose of the law. Okay, now this is simple definition of Salmond's, you can say simple definition of law by Salmond, or Salmond's view relating to law. However, it has been criticized. See what he says, law is body of principles recognized and applied by the state. He should have first defined the law. He is not defining the law. He is just telling that law is recognized and applied by the state for administration of justice. But what is law? By what material the law is being made? Salmond is not telling that. Okay, we will see the criticism. The first criticism is what? His definition is starting from action. Means what he says, law is there for justice. So he defines law as for justice, recognized, applied for justice. So his definition is starting from action. The direct purpose for which law is being made, he is telling that judges act means judges decision is the application of the law. A definition of the law starting from their action would therefore somewhat be like definition of a medicine as per Salmond. See, if we are asked, tell what is medicine, what we will tell? We will tell something which cures disease, or some preparation, some things which are being prepared for relieving the pains, removing the disease, eradication of disease. Means we are going to connect the medicine with the disease. Means some preparation for removal of the disease. Like that we will define. But if you give this word medicine to Salmond and apply his definition of law towards it, the way Salmond will define medicine is what? That which is prescribed by the doctor. Because what he says, law is there for justice. law is that which is given by the court. If law is that which given by the court, then medicine is what? That is given by the doctor. Like that he is being criticized. Therefore, his definition of law is not a proper definition. He is telling directly the action of law. Okay. Now, other criticism is what? His definition is running in the circle. See, administration of justice. If we see what is administration of justice, it means application of law. How justice is administered? Through law. Execution of the law, you will get justice. Now, what is his definition? Law is those body of principles which are recognized and applied for administration of justice. And what administration of justice is defined? That which is we get after application of law. So, administration of justice is defined as application of law, and Salmond defines law as what is administered by justice. Therefore, his definition is running in circle. A is equal to B, B is equal to A. A is equal to B, B is equal to A, like that. It's running in the circle. He tells administration of justice is application of law. And what is application of law? Administration of justice. So, his definition is wrong. It is running in circle. Okay. Now, formulation, third criticism. Formulation of law necessary precedent. See, justice is done. Okay. But before that, law is prepared. Law is there. It is applied. And then we get justice. Here what he is telling, justice is what we get by application of the law. Means what the judge declares, that is law. Means first is justice and then is law. Therefore, formulation of law is necessary precedent, and he is telling just the opposite. Formulation of law is a necessary precedent to administration of justice. Definition of Salmond is defective as it assumes that law is logically subsequent to the administration of justice. Means for him, what the court declares, what the judge decides, that is law. But that comes afterwards. Before that, law is there. Judge applies the law, interprets the law, and then gives the justice. Okay. Therefore, law is prior, precedent, then justice. But according to him, justice creates the law. Therefore, his definition is not proper. Okay. Now, another criticism is what? His definition is not proper because he says what the judge decides, that is a law. The judge may misconstrue, the judge may misinterpret, but that is a law. How come it can be a law? Why you are denying the parliament's powers to make law? Means we are giving the powers of law making to parliament. Means parliament makes the law, executive execute the law, and judiciary gives justice. That is the function of all the three organs. But what he is telling, statute is not law. Why he denies the powers of the parliament? Statute is not law because it may be misinterpreted. Means he says that statute is not law because it can be misinterpreted. But we have seen that there are many judicial decisions which are misinterpreted, and as they are misinterpreted, the matter goes in appeal, and the higher court, what it does, it overrules that judgment. Now if it overrules the judgment, it means what? The prior judgment, the lower court judgment was misconstrued, it was wrong, therefore it has been overruled. Therefore a judge can also misinterpret. If law can be misinterpreted, then a judge also can misinterpret and give a wrong judgment. Therefore he is thinking that whatever judges do, that is final. They may misconstrue. No, they may misconstrue, but that will be challenged and the higher court will overrule it. Okay. Now purpose of law, he says, is justice. But we know that the only purpose of law is not justice. There are other purposes also. The purpose of law is what? To have law and order in the society, greatest good of the greatest number. These other purposes are there. Justice is the main purpose of law, but other purposes are also there. But as per Salmond, he says justice. Law is there for justice. So he is giving restricted meaning also for the purpose of law. Therefore, his definition is improper. Okay. Now, what it tells, justice is that which is given by the court. Law is that which is given by the court in the form of a justice. The court, the judges, which the word he uses, it is in a form of a traditional judiciary. But nowadays, what we have done, many of our cases go to tribunals. Now, tribunals, administrative tribunals, they decide the matter. He ignores administrative law. Many questions are no longer decided by the courts of law. They go to the tribunals, and he is giving importance to our traditional judiciary. Therefore, the definition is very narrow, and he ignores the administrative law and administrative tribunal. Okay, this is the definition of law given by Salmond. Law may be defined as body of principles recognized and applied by the state in the administration of justice. Okay, bye bye. See you in the next video.